Mr. Dean, do you think you're going to have any witnesses for that motion, sir?
That motion is never going to be heard. That's a frivolous motion, and I filed to dismiss it. I have like a dozen motions pending.
Yeah, I just wanted to have an idea if you have any witnesses pertaining to this motion, should it go.
Well, this is, again, as she just told you, it was filed June 23rd, 2023, and they labeled this an emergency motion. So the first thing that should happen is that you need to rule whether or not it's an emergency, and that was a year ago. So once that happens, then we can discuss that.
Okay, well, respectfully, I don't think she said emergency. I think she used the word urgent, which puts it in a different category, Mr. Dean.
So then that urgent from a year ago?
Well, and that's something you can certainly address during the hearing.
Okay.
I mean, that's
but
something
she also failed to mention about 6 other motions she filed in advance of that one. They're just trying to move to the most recent filed one because it sounds like something that they can get a leg up in this case.
So what that is not accurate, and I have transcripts of everything, and yes, he is correct. And he's had hearings, 3-hour hearings.
I'm not really sure why she's interjecting here. It's my turn to talk, and I'm not really sure why she's involving herself. This is what she does this all the time.
One second. I cannot. Okay. So
she just jumped in out of nowhere.
I need you to tell me because I'm not going to go through 400 and something entries
to figure out which motion. To be perfectly honest, I was expecting you to come on this hearing and just start admonishing me like the other judges have done in the past. So I was just ready to sit here and tell you all the unlawful things that have been happening. I wasn't ready with all my motions, but there's like 30. The most important thing is this. I have a motion for temporary relief so I can have alimony so that I can afford an attorney, so I can stop having the stress as a 100% service disabled United States Marine to have to lose the amount of sleep I lose to prepare for these cases as a pro se litigant, and for me to play lawyer when I'm not a lawyer because I'm forced to do this because for 2 years now I've had a temporary relief motion pending. I have a motion for contempt against my wife pending. She's taken my kids out of the state. She changed the locks. I'm sorry, a phone call came in, so it stopped me. So my wife has been taking the kids out of the state. She changed the locks on my house, even though the cops have told her multiple times she couldn't do that. She's made multiple. I have 4 false domestic violence allegations against me. We can't just keep going forward. You got to evaluate what she's doing. So we'll move right. Let's move right forward. Don't worry about scheduling anything. We'll move right forward to the next things I was going to say, which is that this hearing was not scheduled with the required 5 days notice. I already filed a motion to recuse you last week, which you denied. It's clear that there's a bias in this case. You are friends with the last judge who was recused for bias. She was involved in ex parte communications. So the odds of you and the last judge communicating about this case before today is more likely than probable. Said he personally, randomly reassign this case to the friend of the last judge. This is not fair, and I will be filing another motion to recuse you today since you're not willing to give this case the attention that it deserves. You said it so yourself, and that's unacceptable. My children deserve better than that. I deserve better than that. The judicial system deserves better than that, and that's not going to happen. 7 judges were recused for bias. You cannot adopt those orders and move forward.
I'm not. You did not set it for hearing, sir. That's why we were here.
That's not one that you set for hearing. That's not one that you don't set that for hearing. That is to be ruled on by the Chief Judge Jack Tudor.
All right. So your motion to change venue can be set for hearing, and that's one of the ones I was going to set for hearing. So
along with a motion for an urgent motion for psychological evaluation from last year. And I filed for a hearing on each of those. I can't go back in time, and I can't go back to 2 years ago and ask you for a hearing today. I filed for hearings with the respective judges.
What date was your motion for psychological evaluation filed, Ms. Rodriguez?
June 23rd, 23, and I would like to be heard, Your Honor, at some point.
You will. Okay.
Oh, she's been heard plenty. All the judges hear her and not me. I get muted. The judges hear her out completely, and all you're going to hear from her is lies. So let's don't waste our time.
Hold on, sir. You're going way too fast for me, and I need to.
Oh, now I'm going way too fast, but you were willing to just move forward with the other side's whims, at their whim, and everything they're saying is misrepresentations.
Mr. Dean,
This is egregious behavior.
Okay,
It's not about arguing. I'm telling you facts. I'm not arguing. I'm just telling you what it is.
Your Honor, may it be by Zoom, please?
It is by Zoom, and
Oh, no, I objected to Zoom. She likes to go back to old orders from biased judges, but let's go back to the last judge with another biased judge and another bad order. I objected to Zoom, and there's an order that says we're going to do everything in person. So unless you're going to go back and reconsider all orders, I will see you in person.
We're going to have the motion via Zoom.
It was already ruled upon.
Perhaps for prior motions, not for this one.
No, for all motions moving forward, it was ruled upon in person. You can't change an order. You can't just change an order unless you're changing them all.
Hearings will be via Zoom. Mr. Dean, you can file whatever.
I'm also gonna file a notice for you to see that this was ruled on, that all hearings moving forward are gonna be in person, and you just now sua sponte decided it's not. But what you're telling me that you don't do sua sponte stuff, you just did something sua sponte.
Okay, Mr. Dean, you can file, like I said, anything that you want.
I know I can. I don't need your permission to file. I know that.
You could reach out to the United Way of Broward County. They have the Mission United.
Oh boy, here we go. No, they don't take complex cases like this. There's nothing there's no resource you're going to tell me about that I haven't already thoroughly evaluated. What you're going to say is this is a bunch of malarkey. This is a bunch of malarkey. What I need is the same lifestyle that I've had in my marital. What I need is to not go bankrupt. What I need is a lawyer to represent me. What you're doing is denying me that opportunity. So you're holding me hostage as a pro se litigant. You're not hearing temporary relief first so I can get a lawyer. Instead, you're going to force me to represent myself pro se. Thank you. I appreciate it. Thanks for nothing. Look for my motion to disqualify you shortly here this afternoon. Well, I would like to make it clear for the record that I will read the email that I received 4 days ago from this court. For the record, good afternoon. Judge Masarago wants to see all the parties for a motion calendar hearing. Thank you. Your set motion calendar hearing on 7/3 at 9:45 via Zoom. That is what I received. Thank you, madam.
Okay.
So we're not here to hear any motion to stay.
Okay.
And that's why I said I'm not prepared to argue the merits.
No problem. Next time, say it at the beginning instead of saying it at the end after I have ruled. Okay?
You never mentioned that you were hearing the motion to stay. You just ruled on something we weren't hearing. You were here for a case management conference, and out of nowhere, you busted out a ruling for a hearing that we're not even having. So and then tell me I'm not paying attention at the same time.
I'm asking you a question and you're refusing to answer.
I'm trying.
Are you available July 19th?
I'm trying to answer, but you don't let me get a word out. If I could please make a complete record before you next speak. I was telling you, you told me you read my emails, and in the emails I said, yes, I'm available July 19th, but it's inappropriate to wait that long to have this hearing because they submitted two notices of unavailability, but they have far more than 2 litigators. I've already litigated against Brianna Stern as well, and she did not submit a notice of unavailability. That's why I'm saying it's ridiculous to wait, because they sent 2 notices of unavailability knowing they have extra litigators. They should be heard before then.
My JA told me about the inappropriateness of the emails. I do not read the emails.
But you told me I was yelling at your JA on an email. How could you tell me that if you didn't read it? So you're telling me you took her word for it, and you're gonna come and tell me off about something you didn't even read? So you didn't even read that, and you came to talk to me that way? This is extremely disappointing.
I don't mean count to 3 like you're my child, and you can record all day long.
I know I can't.
Record all day long.
I know. And I'm asking you, why are you trying to...
Because those are the rules, that's why.
Because there's rules. Can I see that rule, please?
He wants the video. He told me he has to be there. He doesn't want to go back there.
Yeah.
So he's gonna
Do you have any reasonable, articulable suspicion that I committed a crime? Am I being detained?
Don't go in there. I have to escort you out because the rules are
And I ask you what rule?
30 respondents, you were responding to.
May I see the rule? Because it's not on my notice of appearance of the court. There's nothing about wearing red tags and going in rooms. If you cannot show me that, I'm not... Unlawful orders are not orders at all. Is it inconvenience for you not to abuse my rights? Is that what it is?
I didn't hear what he said.
Do you feel it's inconvenient for you to abuse my rights? Is that what it is? Can you please not walk so closely behind me, sir? Oh, I thought you said you wanted to show me something. Alrighty. I want to be difficult because I have rights. So you guys view rights as difficult.
All right, let's go.
Let's go where?
Is he supposed to be in here?
Let's go where?
Where's he supposed to be?
In the respondent's room.
Sir, there you go.
No, thank you. Do you have any reasonable articulable suspicion that I committed a crime? Am I being?
Sir, you're supposed to see the respondent. You're a respondent right now.
Am I being detained?
Do you want to cooperate or you want to leave?
I'm asking for the rule.
Do you want to cooperate or do you want to leave?
By cooperate, do you mean cooperate with you abusing my rights?
By going into the room like you're supposed to, or,
Says who?
Or we do.
Says you said so. So I'm going to go in this room because you said so.
Yes, so.
Negative.
Right,
do you have any reasonable articulable suspicion that I committed a crime?
You can leave then, okay?
Okay.
If you don't want to, you don't want to cooperate. You
Cooperate.
Yes, sir.
Cooperate with you guys abusing my rights? Last time we met, this court unilaterally scheduled a CMC and added this motion the day before the hearing, and then heard this motion and failed to perform any of the duties of the CMC, as if there was no CMC at all. But still, nothing changed from last hearing, which is that this court may not hear this hearing until jurisdiction is gained, and I have to today still lack service. You can't have a lawsuit without process of service, and I've written a motion for clarification, so this court will rule on that first. Because this court has not ruled on that, all you're hearing is one-sided story, which is also unfair to me. And that's part of the reason why I filed a motion to disqualify you last week, which you also did not rule on that, which you were supposed to rule on that before you scheduled this hearing, but instead you went ahead, forged ahead with this hearing, and then of course denied my motion to disqualify you because it would have been pretty silly to recuse yourself after you went through all that trouble of writing those orders. Thank you, Your Honor. I would like to begin by reminding this court of its judicial oath to uphold and support the Constitution of the United States of America as per Florida Statute 105.031, subsection 4B, and also remind this court of its judicial oath to support the Constitution of the United States and the state of Florida as per Florida Statute 876.05, subsection 1. Furthermore, in making its ruling on respondent's recent motion to disqualify, this court has declared that it can and will be fair and unbiased, moving forward. I will accept that statement in good faith. The purpose of reconsideration is to remove the taint of prejudice where rulings might be perceived as tainted. I did make a record last week that during the hearing where the stay away order was implemented, I actually had to defend myself on the hallway, on the floor of the hallway outside of your very courtroom. That is clearly not a fair trial. Florida rules of judicial administration provide that upon receipt of a motion to disqualify, the judge shall enter an order granting to disqualify, but the judge did not do so. He waited 5 months and made 3 other rulings. I will show the court today emails between myself and the JA in which the judge subsequently disqualified himself 2 hours after my email. Okay. Yeah, we're here today to reconsider and to vacate that order based upon poor administration of justice, based upon fraud upon the court, and those are 2 of the 4 reasons that you can reconsider any motion. I would also, I would like to read to you.
You're not introducing evidence today for me to make a ruling. The whole purpose of today was legal argument why you think I should vacate that order, why I should reconsider it, vacate the order, and then give you a new hearing on that motion. Okay? So I don't know, you wouldn't need to introduce your 911 recording or anything like that today. Again, today's just the argument of why I should vacate that prior order.
And that's exactly why, because there's new evidence that wasn't at the original hearing. But anyhow, in North Shore Hospital, Inc. versus Baker, in the Florida Supreme Court in 1962, the Supreme Court reaffirmed the long-standing tenet that a trial court has the inherent authority to control its own interlocutory orders prior to final judgment. That means you may consider all motions at any time prior to final judgment. Further, in 1984, the 4th District attempted to clarify this apparent contradiction in Commercial Garden Mall versus Success Academy Incorporated, also in the Florida 4th District Court of Appeal, 1984. The court held that while non-final orders were not subject to a motion for rehearing, a trial judge nevertheless has the discretion to choose to entertain such a motion precisely because it has jurisdiction to control its non-final orders prior to entry of judgment. Therefore, you may look and even rehear any motion at any time. You have the standing to do so, which is why they didn't seek the stay away order during that date. That was just given to them because the judge already had me on the floor in the hallway. You shouldn't have, indeed, you should not have heard anything beyond that. I mentioned this to you last week. Sua sponte, once you heard that I defended myself on the hallway floor outside of your courtroom, you should have already vacated this. This is already wasting precious resources of the court system to have us here today. There's 2 small children, 3-year-old and a 4-year-old, that haven't seen a father in 17 months. It's going to be 18 months.
And that what? Then you sat outside on the benches and
that is incorrect.
Had the hearing on your Zoom?
That is incorrect.
What is?
If I may explain. Thank you. So I arrived approximately 1 p.m. for the 1:30 hearing, and I told them I'm here to appear for the 1:30 hearing. The sheriff said to me, "There's nobody doing in-person hearings." So I broke out my notice and I said, right here, it's noticed Zoom or room 11156. I'm pretty sure any prudent person, given the opportunity, the choice to appear in person or on Zoom, a prudent person would arrive in person. So I did so. And about 15 minutes passed, and we found the judicial assistant out in the hallway, and I showed her the notice. Look, I was noticed to appear in person here, so I'm here. Please let me in the courtroom. She went and talked to the judge, came back, she said the judge is not letting anybody in the courtroom. So then I sent her back again. Can you please tell the judge, if he's not going to let me in the courtroom, which he noticed me to do, can he at least give me a 20 minutes continuance so I can go back to my office and defend myself in private? She disappeared. She came back. Now it's about 1:35, 1:30 something. And she said, the judge wanted me to tell you that he's already started the hearing without you now, and he's gonna give a default judgment against you if you do not appear in the next 5 minutes on Zoom. You may look at the record of that hearing, and you'll see before I arrived, he did say that to the court. Oh, Mr. Dean arrived in person. I'm going to square this away. I'm going to give him 5 minutes. What could I do if I'm knocking on the courtroom door, if I'm right outside of your door, and you give me 5 minutes? Where could I possibly go? Where could I possibly defend myself? How is that fair? In the duress that put me under, the immense duress, and you already know I'm a 100% service disabled veteran, to have me not on the bench, on the floor, with my stuff spread all over the floor that I can't find anything. And I had three physical copies of evidence to present. And now he says it's a Zoom hearing. So guess what? I went from all my evidence and exhibits in person to I can now have no exhibits because it's no longer in person. So my 3 physical copies are dead. So now I have no evidence. I'm on the floor. I'm panicking because people are walking by me. I'm under incredible duress. And there's no possible way that you can say that that's a fair trial. That's a fair hearing. It's clearly not.
On October 17th of 22.
Yes.
There's nothing that you need to show me. The order of recusal is on CMS. I have seen the order of recusal.
What she's
So
saying,
what else would you like to argue?
what she's saying is that he recused himself for some unknown reason, but it was not prejudicial treatment towards me. But if I can show you an email sent 2 hours before his recusal, 2 hours before his recusal, you'll see that he was saying, I want to see you guys in person. And I said, you're going to see me again in person so you can put me on the floor outside of your courthouse? Is that what you're going to do? And then he recused himself within an hour. That is not a fair trial. That is absolutely pertinent for you to make your ruling on this hearing. And for you not to see it is again denying me my opportunity for a fair trial. Motion for reconsideration can be heard based upon fraud, but you're not even willing to look at the evidence of fraud. My motion for reconsideration is based upon fraud on this court, which this court would not allow me to show, and also based upon a clear, unadulterated, prejudicial, unfair trial. There's never been a more unfair trial in the 17th district than there was that day. I can guarantee you that no lawyer in the history of our country has ever had to defend anybody on the not a bench, as you tried to allude to. No. The floor of a hallway outside of the courtroom door with people walking by, and for Miss Bonner to say, that's fair, that's absurd. That is misrepresenting her knowledge as a litigator. This court knows very well that that's not a fair trial. You, in fact, yourself told me last week, Your Honor, that if that was the case in your courtroom, that you would have not had me outside the court. You said you would have brought me inside the room, and you showed me the little TV that I would have been sat in front of. That is not what happened there. So clearly you do not see that as a fair trial. Please uphold your own word and grant my motion to vacate this motion for reconsideration. Thank you. I'm gonna move this court to disqualify the judge at this time. Your prejudicial treatment is noted.
Sir.
Well, I've made the verbal.
You're not muted. You can put it in writing as the law requires.
No, it does
You
not
can put the
require.
motion in writing.
It does not require
folks,
that.
I don't think we have any of the other stuff.
The motion,
set, so
I can
if
make
we
that
do-
motion in person, and as I've done, it's an oral motion.
Sir, I'm not allowing you to unmute yourself again. You have to put it in writing. You can file it, and I will rule on it. Okay? Thank you, folks. The hearing is over.
Oh, she called the police. Oh, you called the police. For what? Hey, what's up, guys? What's going on, fellas? Officer Vasquez, Officer Calvo, and Officer Ramirez. No, can we talk right here? I'm waiting on a car rental.
Do you want him trespassed or?
Want me trespassed?
Give me a second.
Do you know how trespassing works, sir?
Sorry, how you
Do
doing?
you know that they have to ask you to leave before you can start that? You've already violated my rights, asking him if he wants me trespassed. Nobody's asked me to leave. You did. No, he did not. You asked him if he wants me trespassed. And that's what you asked. You said, do you want him trespassed?
Okay, let's calm down for a minute here.
Sure, I'm calm. I'm perfectly calm.
If they don't want to do business, man, they don't want to do business.
That's not how it works, but okay.
It's a private business.
I understand what it is. It's a franchise, but I understand what it is.
And if they don't want to do business, they don't have to do business.
Yeah, well, that's fair enough, but there's going to be recourse.
Okay, that's fine. That's fine.
Sure.
You can take it up in court.
Yeah, but you coming in here, John Wayneing it, ain't going to work. You just asked on film if you want him trespassed.
Right.
You didn't ask him, have you asked him to leave? Did he ask if they asked me to leave?
Oh, you're right.
No, you didn't ask that. So you just violated my rights right away. That was obnoxious to do that. So just say I'm sorry, and I'll just apologize.
My apologies.
Okay, fair enough. I'll accept that in good faith.
Could we go outside and talk calmly?
Sure, in good faith.
Thank you.
But not because I've been trespassed, not because I've been asked to leave. For the record, I've not been asked to leave. The only mention of it was when you asked me if I wanted to do trespass, and that's absolutely out of control. I accept your apology in good faith. I'll grab my stuff and we'll continue this conversation on film outside.
No problem. Thank you for cooperating.
No, my pleasure. I'm extremely distressed. This is unacceptable, and I have everything on film that's happened here. And there will be recourse, and calling the cops before asking me to leave is another issue we're going to deal with.
Mr. Dean, you're here for both parties?
Yes, ma'am.
And are you an attorney?
I am not.
So there's going to be an order today, if there wasn't already an order reflecting that you need to get counsel within 10 days, okay?
Well, we can't make any orders at this point. You don't have jurisdiction to even hear today's CMC nor the motion to strike. I challenge jurisdiction.
I'll decide that, okay?
Right, but that does need to be decided. You needed to decide that before we came here today, because I filed a motion for clarification. My stance is that this is an ambush tactics employed by this court. I was notified of this motion for this hearing yesterday afternoon, which would be 0 days notice, as opposed to the law rule 1.090 subsection D that requires 5 days minimum for service, which I'm certain this court knows that, and still this court unilaterally scheduled this motion, which is why I'll be filing a motion to disqualify this judge later this afternoon. But this court has failed to establish jurisdiction because I filed a motion for clarification on why the last judge was recused. She claims to be recused for sua sponte, but 2 years in, she recused herself 2 days after I filed a motion to disqualify her, thereby basically handcuffing me and saying she left by herself, so now I can't challenge her old rulings, which is unfair. Okay, have a good day. That was absolutely unacceptable, but we'll address it later. I thought you read the emails, and I articulated very clearly in those emails what you said.
I muted you, so you cannot interrupt me when I'm speaking. All right, I have a pretty lengthy docket,
Respect must be mutual. You can't cut me off and then ask me not to cut you off. And I can go ahead and tell you we don't need to bother because I'm going to be filing another motion to disqualify you. So we can see justice is not going to be served so easily. All I did was appear, and I was being admonished before I even said a single word. I scheduled that case management conference, and I should have been the first one to be able to speak. And she went straight to the opposing counselor to ask, basically, how do you want to railroad this guy? As you can see, judge number 7 is she's going to try to force status quo on me and continue the same direction that we've been going in now for 3 years. And that's unfortunate because while she allowed the opposing counselor to make a full statement just now, she wouldn't allow me to say a word. While she was telling me I'm not allowed to cut her off, she cut me off every time I spoke. Respect is mutual, it's not one way. And as we can see, the court feels like she's above the law. I'm not. I refuse to be spoken to in that manner. I refuse to be railroaded. I refuse to let fathers go out like this, and I'm going to stand for all fathers. And I'm going to make my statement here to this camera that I was going to make to the court, so the record is clear. Your Honor, my service to this nation, highlighted by the Presidential Unit Citation, mirrors the highest collective honor, akin to the Medal of Honor for individual bravery. It is a testament to facing adversity with valor and unity, qualities that underpin my pursuit of justice within this courtroom. As we move forward, it is essential to understand that these traits are the bedrock upon which I stand in seeking a fair resolution to these proceedings. The conduct of the opposing party and her counsel stands in stark contrast to the honor of fair play and justice. Their actions have moved beyond the pale of reasonable litigation into the realm of systemic fraud and legal abuse. This behavior, which has significantly hindered my ability to maintain a relationship with my children, cannot be overlooked and requires immediate rectification to restore the integrity of the legal process. With the complexities of this case sprawling beyond the purview of brief judicial interactions, I implore the court to authorize a comprehensive social investigation and engage amicus curiae. These steps are not mere formalities, but are essential for shedding light on the true dynamics at play, which have been obfuscated by the opposing party's misconduct. The rotation of 7 judges through the life cycle of this case has resulted in a fragmented understanding of the events and the issues at stake. establishing a stable judicial presence is paramount to ensuring that decisions are made with a complete and continuous understanding of the case history, particularly given its direct impact on my children's future. As a father unjustly separated from his children, I stand before the court to appeal for a path forward that honors my right and duty as a parent. For 3 years, I have been estranged from my children due to a series of uncorroborated allegations and a legal system that has yet to rectify these wrongs. The injunction placed against me without proper accusation or hearing has only perpetuated this separation. This case began with a disproven claim of domestic violence. Yet the shadow of that claim continues to unjustly dictate the terms of my relationship with my children. The time has come for the court to take definitive action to redress these injustices. A just path forward begins with lifting the baseless injunction that has marred my reputation and hindered my ability to be a parent. It involves establishing a framework for my children to have the benefit of 2 parents involved in their lives, as they rightfully deserve. For nearly 2 years, the current injunction has stood as a barrier to this fundamental right, with no substantiated basis. Justice must prevail not only in word, but in action, beginning with the court scrutinizing the events that have led to this prolonged separation. The court must consider the damaging effect this has on the welfare of my children and act swiftly to restore my parental rights, thereby enabling a healing process that allows for the rebuilding of my relationship with my children. This path forward entails setting aside the injunction that has been unjustly imposed upon me, facilitating a fair and immediate reevaluation of custody arrangements, and ensuring that the petitioner adheres to the court's orders without evasion. It is only through such divisive measures that the court can protect the best interests of my children and ensure that justice is not just a concept, but a lived reality for my family. I urge the court to consider the grave impact of these years of separation on both a father longing for his children and the children who have been without him. I stand ready to cooperate with all necessary investigations and proceedings, and I do so with the hope and expectation that this court will act to mend what has been broken starting today. As this case languishes in a state of judicial inertia, I wish to draw the court's attention to the numerous outstanding motions that continue to impede progress toward a resolution. It is a matter of record that the opposing party has filed an abundance of motions frequently labeled as emergency or urgent. However, there is a stark disparity between the purported urgency of these filings and the opposing party's actions, which show willful negligence in prosecuting their claims. This pattern of behavior exhibits a strategic misuse of emergency motions as a means to manipulate the court's docket, thereby prolonging the proceedings unnecessarily. Such tactics not only burden the court's resources, but also serve to perpetually extend a state of uncertainty and strife within my family's life. It is a calculated effort to exhaust both the judicial system and my own capacity to seek justice. The urgency with which these motions are marked stands in direct contradiction to the opposing party's lack of diligence in pursuing them. This approach not only hinders the timely administration of justice, but also detracts from the genuine emergencies that require the court's immediate and undivided attention. I respectfully urge the court to recognize the dissonance between the opposing parties' claims of urgency and their subsequent inaction. In the interest of judicial efficiency and the welfare of my children, I request that the court prioritize the review and disposition of these motions with a critical eye towards their merit and necessity. The path to justice is being obstructed by a barricade of unfounded emergency motions, and it is within the power of this honorable court to clear the way. I stand ready to engage constructively with the court's processes, to respect its time, and to uphold its directives. However, it is imperative that the court addresses this pattern of behavior that serves to derail our collective efforts to reach a fair and final resolution. In closing, it is time to move forward, to act decisively on motions that have lingered without just cause, and to bring this case out of the procedural quagmire it is mired in. For the sake of my children and the principles of justice, I seek the court's assistance in bringing these matters to a close. Thank you. That was the statement I prepared for the court this morning and was so rudely, so oppressively not able to say. I'm at a loss of words. I feel like our country is lost, democracy is lost. That's the first time I ever saw that lady. I don't know who she is. For her to come in and start talking to me that way is discouraging at best. To disparage me and admonish me before I even spoke. To allow the other counselor to speak before me when I scheduled the hearing. And to never allow me to even say one complete sentence without interrupting me. I'm baffled, I'm dumbfounded. I'm shocked. And now my babies are gonna have to wait months more. My goal for today was for them to just look at the injunction and vacate that so my children can have a father. I wasn't even allowed to mention it. It's as if the kids in this case don't exist. On that, I'll sign off, and I look forward to hearing what you have to say. Was that fair and impartial?